Hello, my name is David Lepofsky. I'm chair of the Accessibility for Ontarians with Disabilities Act Alliance, and I'm also a visiting professor at the Osgoode Hall Law School. With 7 months of the COVID-19 pandemic swirling around us, healthcare systems around the world have been confronted with the possibility, and in some cases the reality, that there could or are more cases being presented at hospitals than there are beds, services, and equipment to provide critical life-saving medical care for COVID-19 patients. If that situation arises, thankfully it hasn't arisen yet in Ontario and hopefully never will, how will the healthcare system decide? Who among those needing critical care will get it, and who will be told, sorry, we know you need it, we know you're covered by our insurance system that's publicly funded, but we're not going to provide it because we don't have the space. And how will those decisions be made? Indeed, who will make those decisions? Facing this as a possible issue last February, the Ontario government appointed a bioethics table, a committee of doctors and bioethicists to draft a protocol to govern critical care triage. And that bioethics table consulted with some within the healthcare community, but not with the broader public, not with the disability community, and wrote a protocol, a critical care triage protocol dated March 28, 2020. Ontario Health, part of the Ontario government, sent that March 28th protocol to all Ontario hospitals. However, it has never been made public. The government never announced it was having it created, and indeed, the government never initially announced it was even out there. It was leaked to the disability community, who were never consulted on its development, late in March or early in April 2020, as a result of which actions were taken by a number within the disability community to object to this original March 28th protocol on the grounds that the way it would provide for making decisions, life and death decisions over who gets critical care, threatens discrimination against some patients because of their disability, contrary to human rights laws. On April 8th, 2020, the Arch Disability Law Centre made public an open letter to the Ontario government. It was co-signed by a good number of disability organizations, including the AODA Alliance. It complained strongly that the triage protocol discriminated against patients with disabilities. On the 14th of April, the AODA Alliance made public a discussion paper in which we suggested some of the key ingredients that should be included in any triage protocol in this area. Public pressure on the government mounted. As a result of that, in April 2020, the Ontario government announced that this was only a draft, though they never rescinded it, and it remains in force to this day unrescinded. They never made it public, but they did announce that the bioethics table would consult, or the government would consult, with the broader community, including human rights and community experts, on how it should be revised. Over the summer of 2020, the bioethics table consulted with a number of people to whom it did outreach within the disability community. I and the coalition I lead were among those it consulted. We had several meetings, and they provided us a draft, or a revised draft, of the critical care triage protocol. We had several meetings virtually because of COVID to discuss our concerns and ask for more information. On August 31st, 2020, the group of us who were raising these concerns from the disability perspective made our final presentations to the bioethics table. The video that is about to follow is a 20-minute recording of my closing presentation to the bioethics table. Let me provide just a little information to provide some context for it before you see that actual video. First, accompanying it were written submissions dated October 31st that the AODA Alliance filed, and September 1st that the Arch Disability Law Center filed. We were working in close harmony, and we were endorsing each other's presentations. It is important to read those to get more detail than we could squeeze in our closing presentations, including in the 20 minutes that I had to present and that you're about to see. The bioethics table rendered its final reported recommendations and sent them to Ontario Health on September 11th, 2020, and to the Ministry of Health of Ontario on September 14th. They were also sent to the Ontario Human Rights Commission. We've never seen them. They've not been made public. On the 25th of September, we wrote the government to ask to see them, and the government has not answered. The government has, however, told the media in our news articles recently that these are not being disclosed, at least now. So we don't know what's going on. We don't know what their plans are, and the government isn't consulting with us or talking to us about it at this point. The other thing you need to know, just to clarify what you're about to see, is the following. First, I was not appearing as counsel, as a lawyer for the AODA Alliance. I was appearing and presenting as its chair. Next, I was the second presenter. Before this, and not including this video, was an excellent presentation by the Arch Disability Law Center made by their counsel, Miriam Shanuda. More about what she had to say in a minute. Third, you need to know that at the core of this entire discussion is something called the Clinical Frailty Scale. Both the March 28th protocol, triage protocol, and the subsequent revised draft protocol on which we were commenting, both use this Clinical Frailty Scale, or CFS, to decide who would get critical care and who would get triaged out if an overflow took place. I emphasize that overflow has not yet taken place, and we hope it won't. So how does this work? Well, a patient with less than 6 months to live would be triaged out automatically. But for anyone with more than 6 months to live, if they have a progressive disease, then the protocol would provide that the doctor would assess the patient under the CFS, and depending on their scoring, they could get triaged in or triaged out. The idea is that the doctor is trying to measure the patient's likely mortality, and they use the CFS as the measure for that. How does it work? It involves simply assessing whether a patient can undertake certain activities of daily living without assistance, whether they can get out of bed on their own, walk, eat, whether they can make phone calls, and do such things as doing their own finances on their own. Those would be the kinds of activities, among others, that would be measured. And they are measured based on a person's ability to do these things without assistance. Before I spoke, Miriam Shanuda basically made two arguments. First, she said that the data or studies that the bioethics table had provided to us in their earlier discussions did not support a conclusion that for the entire population to which the data, the CFS would be applied, 18-year-olds up to end of life, that it provides an actual and accurate measure of the patient's likely mortality. And second, she argued that even if the data supported that conclusion, the fact is that the criteria being used in the clinical frailty scale are a clear violation of the human rights of people with disabilities, of patients with disabilities, because it essentially will disproportionately impact upon and select people out because of their disabilities, especially not only based on on what it measures, but by measuring it without considering the possibility of someone having assistance or accommodation. Now, I need to just give a couple more pieces of clarification for you. At a couple of points, you'll hear me refer to a Dr. Downer. One of the members of the bioethics table is Dr. James Downer, who was a major participant in a number of the meetings that we were having. At several points, you'll hear me refer to the CFS as being subjective. What I meant by that is that any number of doctors looking at the exact same patient applying the CFS could well arrive at very different conclusions, and therefore it risks some serious arbitrariness. It may look like it's some sort of standard or yardstick, but its subjectivity means that it actually could operate in a very arbitrary way. because it is subjective, it risks doctors actually making triage decisions on very different criteria that they may harbor in their own mind. And then the CFS's flexibility leaves them the scope to do that, and we'll never know how they really reached their decision. Towards the end of my presentation, I briefly referred to the issue of due process for patients that might be subject to triage protocol. The actual revised draft of the protocol that we saw last summer did not include any due process for patients. They had no right to know that they were going to be considered for triage, what the criteria were. They had no right to input into the decision. They had no right of appeal from the decision, even though it bears on their actual access to life-saving medical care covered by our health insurance that's publicly funded. The bioethics table had asked us for recommendations. We offered a series of detailed recommendations for the kind of due process that should be included, and they're set out in our August 31st, 2020 written submission of the bioethics table, which I encourage you to read. If you want to see any of the key documents to which I'm referring, other than the March 28th protocol, which is still not been made public. If you want to see the written submissions we've made or ARCH has made, if you want to see the revised draft protocol on which we were commenting, if you want to see media coverage on this, the whole spectrum of that range of information is available at our website at www.aodaalliance.org/COVID. If you want more information, sign up for our email updates at aodaalliance.org. Go to the sign up link and follow us on Twitter at AODA Alliance. I'm hoping to later make available a public lecture that will go into greater detail in the medical triage protocol issue facing people with disabilities during the COVID pandemic. Here now is the presentation that I made on August 31st via Zoom to the bioethics table. All right, thank you very much. Thank you for all the time you put into listening to us, dialoguing with us, and answering our multiple inquiries. We've all been enriched by that discussion, and our understanding has certainly been enriched by that. I just want to explain at the outset that I'm speaking in my role as chair of the AODA Alliance. I'm not playing the role of legal counsel here. I want to give you our bottom line. Our bottom line is that the revised draft triage protocol that you provided to us is very substantially flawed and must be substantially rewritten. We accept and agree with everything that Miriam so eloquently explained to you. I'm going to supplement that. But I want to begin with two basic points. Number one, the March 28th protocol, that is to say the predecessor to the one that we're here discussing, has not been rescinded. It must be rescinded. The longer it stays out there, the longer it festers and causes the kinds of harms that we are talking about today, and the harder it's going to be to fix things after. So we urge you to recommend to the government to immediately and very publicly rescind it and say it is not to be followed. The second thing is that your committee is dealing with unquestionably incredibly difficult issues. And there's a good chance you're going to have different views on it. We urge you to not feel that you need to simply write one report that everybody in lockstep agrees with. If you all agree, of course, go for it. But if any of you agree with the points that we are presenting, even if it's not the majority view, we ask you to issue a minority or dissenting report. If there are different views at your table, share them with the government and the public. It is very important in a difficult situation like this that the government not get the views only of 51% of the members of your table, but the diverse views of all the members of your table. And I can tell you, having served on and responded to recommendations of various advisory boards to the government in various capacities, that a diversity of viewpoints is expected and is helpful. There may be some members of your committee who came into this process married to the CFS and unalterably still stuck with it. That doesn't mean you all have to be. And that doesn't mean you all have to defer to that view. If you are persuaded, any of you, with any of the fatal flaws that we are pointing out, we urge you to speak out and make that view known. That will enrich the government's consideration and the public's consideration of these issues. Now, let me turn first to the issue of the use of the clinical frailty or CFS scale as an assessment tool or the assessment tool for deciding who would get critical care and who would not. Your starting point, the government's starting point, appears to be Ontario Health's. Everybody's starting point seems to be that this can all be decided in a protocol that's written by a table like yours or on advice of a table like yours and is simply sent out to hospitals. We disagree. There's this little annoying thing out there that will drive a lot of people in public sector crazy on occasion called the rule of law. And the rule of law provides that certain rights can't be taken away unless, at the starting point, it is authorized by law. And when we're talking here about a decision that affects a person's ability to live, a decision of whether a patient who needs critical care, wants critical care, and in ordinary circumstances would get critical care, a circumstance where they would be denied that by a decision that we just don't have enough to go around, that is a decision that affects their very right to life. And it is not a decision that can simply be governed by a protocol that someone writes. It needs to be mandated by law. Now, that may create all sorts of problems for the government because they're in a crisis, but they've known about this for months. And the fact of the matter is, the rule of law wasn't born yesterday, and the government has been able to act on an urgent basis to deal with all sorts of issues, including through legislation. This should not be an exception. Let me jump from there. And by the way, certain of the specific things we talk about in our written submission to you, like the need for a due process appeal right for patients, as we've described it, would be expected to require law to be passed. So we need that done now. And we need your recommendations to urge that upon the government if you can, and if you agree. Let me now turn to the actual problems with the clinical frailty or CFS. In a nutshell, in plain language, what this committee's draft protocol would have done and what the prior March 28th protocol, which is still out there and not rescinded, would do, is basically say that a doctor or doctors would decide who is likely, on patients' access to critical care in a triage situation based on their likely mortality, and to decide their likely mortality when they're at the critical care door. If they have a progressive condition or disease, and they are assessed as likely to live more than 6 months in any event, then the decision of their likely mortality would be based on whether they can independently perform certain activities of daily living without assistance. Their ability to feed themselves, use the phone by themselves, do their finances, assessed by a doctor, is going to decide if they live or die, or at least if they'll get access, I should say, to critical care that would in turn determine, in large part, whether they're going to survive the horrible situation. Now, we realize no one wants to have to do this. No doctors want to do it. I'm sure you folks don't want to have to be designing this. We get that. But that's what we're talking about. And we are concerned that this dresses up in dangerous and dehumanizing and misleading terms of supposed science, a rule which is unjustified and discriminatory. And the very mantle of science in which it purports to be dressed makes it all the more dangerous, dehumanizing, and problematic. To begin with, the burden to justify its use in this situation is on those who recommend it. In other words, we don't just presume it's okay unless someone shows it's wrong. We don't presume it's okay unless someone proves that there's a better way to do it. Anybody who wants to advocate for this, for life and death decisions, has to meet a substantial burden of proof to justify it. And that's before we even get to human rights. That's before we even get to discrimination decisions. And I want to suggest, for all the reasons Miriam gave and a couple of others, that hasn't been done here. In addition to the reasons that Miriam gave, there was a concession not only in those articles, but in the discussion we had in these conversations with Dr. Downer, that this tool, this assessment tool, has subjectivity in it. And subjectivity, respectfully, is not science. And there is no showing presented to us that the studies and the data that supposedly dress this up in scientific justification have been purged of that subjectivity, or that subjectivity has been measured or eliminated or properly controlled. None. And so what purports to be objective degenerates as unfairly subjective. And as Miriam correctly pointed out, once it's a subjective decision, that means it may not be really what the doctor's deciding on at all. Not because they're malintended, but because it gives them lots of wiggle room for other things to affect their decision, either consciously or unconsciously. So it doesn't have to be bigotry. We're not talking about bigotry. We're talking about attitudes or suppositions or value systems that could creep in and that risk actually creeping in. Now, this is the burden of proof is even more significant, I would suggest, because as it's been conceded by members of the table we've discussed this with, this protocol, this clinical frailty schedule was neither designed for this purpose, nor do the studies assess it for this purpose. In effect, if we unleash this now, it turns Ontario into this big, huge experiment. And we respectfully suggest that with the risks proposed or identified, this is not the time or the place or the way to do this. Now, let me just focus on one thing that came up in the discussion, because this is really important. And I want to thank Dr. Downer, both because he was put in the unfortunate position of having to deal with most of our questions and really was trying to be helpful, and we appreciate that. One of the things I asked is, I used as an example a situation now where doctors are called on to assess somebody's likely mortality, and that is for assessing whether a person qualifies to go into palliative care. And they have to assess whether they're going to likely to die within 3 months or whatever it is. And Dr. Downer fairly acknowledged, I'm using his words, that the doctors, when they fill it out, the word he used, and I don't think he means it in a nasty way at all, is that they lie. And what they do is they look at a patient, if I understand the circumstances, and they assess if the person, in their view, would benefit from palliative care, and then fill out whatever forms they got to fill out. And that's understandable entirely and candidly evaluated. But here's the thing. How do we have any reason to expect the doctors would do anything different when they're using the clinical frailty schedule? In the closest situation that would come clear, access to in that case, life-saving care. So the idea that we're dressing this up as science and leave it to doctors, don't worry. And here's the tool. When it's got subjectivity built into it, there's serious problems. Add to that the open and fair acknowledgement, in a discussion I had with Dr. Downer, the doctors aren't trained in this in medical school and using the clinical frailty schedule scale, that some geriatricians learn it, but it's not part of their training. I suggested, and I'm not pushing for one profession or another in saying this, but there's another profession that does a whole lot more work in assessing and working with patients on AODA activities of daily living. That's occupational therapy. Now, for those and all the other reasons that we and Arch have presented, this is not a justifiable skill. So short of human rights concerns, it already is not justified and shouldn't be used. But if we then turn to a human rights consideration, I want to suggest that it just adds more fuel to the conclusion that this is fatally flawed. So if it's not justified anyway, you don't need to consider the human rights considerations. But if you get to the human rights considerations, they're equally fatal to it, and the two together are
make the case against it even more overwhelming. So again, I'm just going to supplement what Miriam said. If you look at this scale, you're basically saying, how much of these activities can you do on your own? Well, that couldn't be put more starkly as something which will create both direct and adverse effects discrimination against patients with certain disabilities. Absolutely. And not only that, and that's not even, I don't even think that's something we could have an argument about it. It's so overwhelmingly clear. But it goes further. It actually builds on and reinforces stereotypes about people with disabilities. And doctors are not, as a group, immune to those stereotypes. Some will have them, some won't. But anything which builds on and reinforces them, let's start assessing what you can do without assistance is seriously fatally flawed. So just to reiterate or build on something that Miriam said, when we talk about intention, well, it's well-intended. It's well-intended is not a defense to proven human rights violations. It is not a defense. And when it comes to disability discrimination, oh, but we meant well is often what we hear. It's often what we hear. It is not only no defense, it's not even mitigating in a serious way, because it is settled as a human rights requirement that we look at the impact. And this, you don't have to look far at the impact here to see its discriminatory impact. I'd asked Dr. Downer at one point whether, if the data had shown that different people's race led to them having a greater mortality in the same situation, would you use race as a criterion? Now, he fairly said absolutely not, and he fairly said the data doesn't show that. And of course, we're not suggesting or implying anybody wants to or would use race as a criterion. Don't get me wrong. I'm not alleging anything to that effect. But in the same way that race or sex would not be used in what he said to us, disability should not be used. Our Human Rights Code, our Charter of Rights guarantees equality to everybody without discrimination based on race, sex, disability, and other grounds. Equality for some is equality for none. And so if we're going to honor those rights, if we in principle say we wouldn't use race no matter what, we wouldn't use sex no matter what, we should take the same position with respect to disability. We are deeply worried that doctors looking at multiple patients, potentially deciding which of them is going to get access to a critical care bed when there aren't enough to go around, may well look at them and form their own, or whoever is making this decision, and make assessments on their own about who's got a better quality of life, who's got greater social utility, who's got more to offer our society, whatever, whether they do it consciously or unconsciously. All of this, all of the subjectivity and wiggle room in this, and the test itself opens the door to that and would never necessarily require it to be voiced, vocalized, or detectable. So we were then asked, as one possible option, what if the CFS wasn't the tool? What if it was just a factored away? And I want to suggest to you that doesn't solve the problem. It disguises the problem. Because then doctors or whoever's doing the assessment can do the CFS assessment and then can use it as much or as little when they're using their own other judgments as to who should get the critical care, whether it's based on their assessment of quality of life or of social utility of the individual. By the way, judgments which people with disabilities seriously risk coming out of the wrong end of, and so on. And so just calling it kind of a make weight or an add-on, there's one thing we've learned in other parts of government decision making. When you say something's, well, it's just a factor, that leaves it to the decision maker to decide, well, I'm going to weigh it really heavily here, but maybe not so much there. How much does it weigh? I mean, how much? 10%, 20%? And not only that, but when you allow that to happen, They don't have to document how much they weigh it. They could weigh it differently for different patients. We won't know. There's no way to track it. It basically is yet another barn door swinging wide open to allow for subjective decisions, then papered over with the CFS score when, to the extent that it serves the goal of the subjective decision. And again, I'm not suggesting anything untoward in people doing this. This is a behavior we've seen in other areas of human endeavor and of government decision making over and over again. Now, one of the points that was made at our last meeting that Dr. Downer made, and it was a really interesting and important point for us to consider, was he suggested, using a couple of the examples that were presented to us, that some doctors, looking at some of these patients that we were presented to us in hypotheticals, might assess the patient as even more frail than the CFS scores them as. In other words, if frailty is going to be the test for likely mortality, and that's going to be the test for who gets the critical care bed, the one with the greatest likely mortality is the one who's least likely to get the bed. And if there's a risk that without the clinical frailty scale, doctors are going to exaggerate the frailty, and therefore it'll work against these patients, particularly the examples of those with particular disabilities. And then it was presented to us that the CFS would actually give those patients an advantage because they would be rated as less frail than doctors otherwise might. Now, that's an important thing to consider because, wow, it makes it sound like the CFS that has all these problems actually will serve the interests of patients with disabilities. Here's the problem. First, as an anecdotal observation, I can't agree, disagree, contest, or reaffirm Dr. Downer's assessment of his colleagues, or any of you who would have the same assessment. Unless this has been studied, unless this has been verified, it can't be used as a rationale. Because it could be that if properly studied, the exact opposite is the truth, or that other factors would influence whether it's true or not. And the second thing is, if it is true, it sure should cause serious concern, which we raise elsewhere in our written submission, about whether this is a decision doctors should be making at all. And at least the assumption that's built into this document throughout the protocol that this is a medical decision, it's exclusively a doctor's wheelhouse to decide. We raise concerns about that otherwise, but I think it should be augmented in light of the concern that Dr. Downer hopefully brought to our attention and which enriches our deliberations of this. Now, I'm going to leave with you in written form, as you now have, the specific due process protections that need to be included. They speak for themselves. Patients, and all of which are missing from both the original March 28th protocol and the revised draft protocol. Those protocols treat the patient as simply a passive subject. The doctor will decide, they will consult with a second doctor, and then they give the patient or their family the bad news. There needs to be a fair and accurate process for both making those decisions, who makes those decisions, how they make the decisions, how they document those decisions, and there needs to be an appeal process. You asked for our input and practical suggestions in an unprecedented area and within unprecedented amount of time. We've pulled together some suggestions for you to consider. Is it the best way to do it? Can't tell you. Will it be challenging to pull it together quickly? We know that. But without these protections, the patients are left even more vulnerable, not only by, no matter what the standard is you use for these decisions to be made. Now then, let me summarize or close with a couple of points. First, these are not just problems, as Miriam said, with the application of the protocol and the clinical frailty schedule. You can't have something that's fatally flawed and say, oh, it's just the application, or it's okay, but we'll straighten it out in how we apply it, how we train people, and so on. This is not something that can be cured that way. However, whatever protocol you use, there are a number of directions that we respectfully urge you to include not only in the protocol, but front and center. We list them in our submission. We initially articulated them months ago in the AODA Alliance's discussion paper on the triage issue. And since then, we've gotten absolutely no negative feedback on those propositions. Now, they don't cure, don't get me wrong, they cure the problems with the CFS. But whatever else you include, they do need to be included. Let me conclude again. Let me absolutely conclude here. And I thank you for your time. Thank you for your consideration. And I want to reiterate what I said at the outset. If any of the points we've made are compelling to you, are persuasive to you, give you concern, we ask you to share them in your report. And if they don't garner a majority of views around your table, and they may, and I hope they will, garner unanimous support. But if they don't, we ask you to issue multiple reports to give rise, to express the concerns that you have based on the presentation that we've made, because it is only by providing that robust and rich range of perspectives that all of your presence and participation in the discussion will be most thoroughly honored, and by which the public and the government wrestling with these difficult decisions will be able to most fully benefit from. I want to thank you all for the chance to speak to you, and I'm eager for my colleagues to be able to say more and to take any questions you have.